Good morning to everybody. Hopefully I can provide some information that would assist you and your consumers as far as obtaining assistive technology if they're Department of Rehabilitation clients, and also present some other options that might be available to acquire AT. And AT is one of those things that are very important to me because if some of you that may not know me, I'm a person who I'm legally blind, so I use AT very, very, very heavily in what I do. So this is a topic that's very dear to me. So if as we go to the second slide, basically this slide is just to give you a background of the organization that I work for, which is Disability Rights California, and we are part of the National Protection and Advocacy System, and we are the Protection and Advocacy Agency here in the state of California. Disability Rights is a nonprofit, private legal agency, and we provide legal services at no cost to individuals with disabilities as far as a person's legal rights. The Protection and Advocacy System started back basically in 1972 when there was an investigation done by then reporter Gerardo Rivera on one of the centers in the state of New York where people with disability was housed, and there were some very horrible conditions and everything. So the government decided to create a program where the legal rights of people with disabilities would be protected. And so that's how the Protection and Advocacy System started. And as we go look at slide 3, this just talks about some of the federal programs that we run here at Disability Rights California. And as I said, because it was a Protection and Advocacy System, everything we do, all our programs except for one, starts with protection and advocacy. And we have different programs. The first program, that really came out of Mr. Rivera's investigation was our PAD program, which is Protection and Advocacy for Individuals with Developmental Disabilities, because it was a center where individuals with developmental disabilities was housed, and those real horrible situations, like I said, existed. So when we first started, when the Protection and Advocacy System started, it was basically geared to provide legal services in all different areas to individuals with developmental disabilities. But over the years, different areas, we started to add different areas where we could cover more people on the other programs and include all disabilities. It started with developmental disabilities, but now we cover people with all disabilities. So besides the PAD program, and I'm going to use a lot of acronyms because, it's just a lot to say, so I'll just use the acronyms. But no, we'll just go through that. But then there's our PAMI program, which is Protection for Individuals with Mental Illness. We also have a PAIR program for individual rights, and also we have one for voting access. And as the next slide shows, we have one for assistive technology for traumatic brain injury. Another program that I am the statewide coordinator of is Protection and Advocacy for Beneficiaries of Social Security. And our final program that is not Protection and Advocacy is the CAP program. Now, in all those programs, like we say, we provide legal, no-cost legal services and advocacy services to people with disabilities. Here at Disability Rights California, we have attorneys and advocates that specializes in each of these areas. Some advocates and attorneys, they specialize in developmental disability issues and concerns with that population. We have those that specialize with patients with mental illness. Under individual rights, that's a lot of our individuals with sensory disabilities. So we deal with people with all disabilities. It's just these different programs is, when you call Disability Rights California, they will put you to the right advocate and or attorney who works on that program. A lot of times we get a lot of cross issues, so you may be working with different advocates and different attorneys that's across the board. Now, the next slide, I think the next slide talks about programs we have here at Disability Rights California, which comes from state contracts, and the reason we always include that because these contracts are part of Disability Rights California, and they also look at more specific services and more specific grants through the state of California, focusing on people with disabilities. One program is the Office of Clients' Rights Advocacy, and that program actually deals with individuals who are regional center clients through the Department of Developmental Disabilities, so they can offer services there. Sometimes services may overlap. OCRA, as we call it, is separate from our legal unit. So when we deal with those programs, we have to have consent forms. I mean, we have two different databases where we don't share information because they're two different programs. But we can handle different issues that they might not be mandated to handle, and then the legal office would handle those situations. So we do work together with them. And our other program is the Office of Patient Rights, and that deals with individuals with mental illness who are in the state hospital system. So we provide advocacy there on a statewide level, and usually at all the state hospitals there is a advocate from as we call it OPR that's stationed there at that facility that we can work with when there are some legal issues that they can't get involved with. And our attorneys on the PAMI program work closely with a lot of the state hospitals and clients with issues in those systems. So that's just a little bit about Disability Rights California, some of the programs we have and some of the programs that we run. So as I said, that's just a look, the first slide is just a look at Disability Rights California and give you a little bit of information about us. And we can handle, we deal with legal rights in all aspects of a person's life, okay? It can be from transportation to employment to housing to discrimination to medical coverage, all aspects. The only requirements we have at Disability Rights California is that the issue is disability related. Okay, we don't ask clients or consumers to prove to us that they have a disability. All we require is that the issue be disability related. That means if, for example, the program I work on, Protection and Advocacy for Beneficiaries of Social Security. So if a person well, that's a bad example because you have to even participate in a program, you have to have a disability. But if somebody called and they say, hey, it's tax time and I want to know I want to get some help as far as doing my taxes. Well, no, we wouldn't assist you with that because that's not a disability related issue. But if it's something related to disability, regardless of what it is, we will look at that and see if it has merit and if there are some services that we could offer. Okay. Disability Rights California, we also, every 5 years, we come up with what we call an advocacy Service Plan. This is where we go out to the community and we do surveys and we do analysis of what the public, things that the public want us to work on as a legal agency. And we develop an advocacy service plan that these are the things that we're going to focus on. Now, that doesn't mean that we're not going to help people in other areas, but there are some areas that we focus on. And one of the biggest areas that we focus on is transition services for students and youth with disabilities. And that can be in all different areas. So that's how we pretty much operate. I'm not going to go into the workings of when you call us and what happens and all of that, because we could talk about that at a later date. But I want to get to what we are here for today, and hopefully it could generate a lot of questions as we go along. Now, I'm using because I also submitted an accessible version of the PowerPoint, and as I said, the reason I do one of the reasons I do that because, like I say, I'm a person who's legally blind, and I know PowerPoints kind of sort of don't work for me, but so is, and I felt, well, how can I do a PowerPoint without doing an accessible version for those of us who are visually impaired? So I created an accessible version that I'm following myself, basically, because if I had the regular PowerPoint up, I couldn't see it. So, and I'm also using my CCTV as we talk. So that's that assistive technology thing. That's a very big part of my life and my career. Okay, the next slide slide 6 talks about the vocational rehabilitation. And what I wanted to do is give you guys this brief look at what vocational rehabilitation is and how we do our job when we talk about the client assistance program a little later on. But on slide 6, it talks about vocational rehabilitation. Okay. And assistive, of course, assistive technology, because that's what we're here for. So slide 6 kind of talk about some of the resources that we use in doing our job with the Department of Rehabilitation and assistive technology. And the first big, I guess you could say, the big thing that we use is, and you guys are probably familiar with this, is the Rehab Act of 1973 as amended. Okay, that's one of the big ones that we use because we use that's the actual rehab law, and everything else that flows out of that comes from the Rehab Act. And also we use each state sets up regulations on how they're going to regulations to implement the Rehab Act. And basically the federal government has, through the Rehab Service Administration, that's the agency, through the Department of Education, that mandates the Department of Rehabilitation program. Okay, now the federal government has also written regulations to the Act, to explain what the laws are, and that's what we usually use is the regulations. Now, each state also develops regulations about vocational rehabilitation services. Now, the state regulations cannot supersede the federal regulations. Most of them mirror the federal regulations, but because all states are so unique that states are allowed to write regulations that may cater to that state. But even when they write those regulations cannot conflict with the federal regulations. So usually when we're doing our advocacy, we fall back on, our fallback is the federal regulations. Because let's just face it, the state of Maine is different from the state of California. So there's not a blanket set of state regulations for every state, but there is blanket federal regulations because we're all part of the United States. And you have every state has a rehabilitation agency, and all U.S. territories have a vocational rehabilitation service. So, but we follow the federal regulations. Now, as I said, most of the state regulations will mirror, but then there are some times when they conflict with the federal regulations, and that's where we come in and we fall back on the federal regulations to make sure that a person's rights are protected, because that's what our job is, to protect the rights of people with disabilities. In California, uses the California Code of Regulations, and as we say, the CCR. So Title IX of the California Code of Regulations is what the state of California uses. We also use different policy directives and technical assistance circulars that RSA, Rehab Service Administration, puts out as far as how to implement different parts of the Rehab Act. Because most time the Rehab Act talk about the Department of Rehabilitation is to provide eligible clients the services they need for entry-level employment, but there's a RSA policy directive that we use a lot, which states that that DOR is not just there. Department of Rehabilitation is not just there to get you into entry level. They can also provide services to maximize your employment. So it doesn't just have to be entry level. Although most of the state departments of rehabilitation, they don't really like that, because that means that they may have to put out more services to get a person into a higher level. But we do use the public directives, which is a part of the law, to make sure that the person can maximize their employment opportunities. And just recently, the Workforce Innovation and Opportunities Act was signed, and it deals with a lot of changes with Rehab Act laws, and basically it just clears up a lot of the laws and put better enforcement into the system as far as a person's right to rehabilitation services. Okay, on slide 7, okay, this is where we talk about the California Department of Rehabilitation. And the California, now, first of all, I want to ask the question, how many of you have had experience with the California Department of Rehabilitation or have clients with the Department of Rehabilitation?
Hi, Michael. This is Kim Cantrell. It looks like about 8 hands went up in the main room, and I'm sure there are people on the phone too.
Okay.
Who have had experience. And as I look at the list, I think a lot of people have had some kind of interaction with the Department of Rehabilitation.
Okay, well that's good. So, the Department of Rehabilitation, and usually I always tell clients and consumers that the Department of Rehabilitation is not this, you know, even though sometimes it may seem like it, they're not this big ogre that's out there just really trying to stop people from getting services and moving forward in their life. There are a lot of, and as I learned when I started doing this work, is there are a lot of rules and regulations that they must follow, you know, from the federal government that sometimes are not what some of us advocates and some of us consumers. Because when I was dealing with the Department of Rehabilitation personally, I had that thought that they are just there to stop me from moving forward. But and I, you know, and I did like a lot of people. I got upset and all of this other stuff, and you know. But then I learned after I start researching it that there are some things that they are bound by the federal government that they can and they cannot do. So the California Department of Rehabilitation is the state unit who's mandated by RSA to provide services to people with disabilities in the state of California who are eligible for DOR services who want to return to work. Okay? So that's what the department does. And the department rehabilitation services is not an entitlement program. It's an eligibility program. So what that means is you have to be eligible to receive the services. You know, I tell clients and consumers all the time that just because you know, we're a person with disability and we want the services to go back to work, we're not entitled to them. We must meet eligibility, which we'll talk about in a second. And as slide 8 shows, this talks about the agency, one of the grants that we have here, which is the Client Assistance Program. And basically the Client Assistance Program used to be federally contracted to the Department of Rehabilitation. And then the Department of Rehabilitation would subcontract out the CAP grant to independent living centers or other agencies in the state to actually do the advocacy work. However, in 2013, I think, well, 2012, and it became official in 2013, the governor redesignated Disability Rights California as California's protection and advocacy system. So what that actually means is now the funding for the Client Assistance Program comes directly from the federal government to Disability Rights California to do the advocacy work that needs to be done so that individuals' rights are protected as they go through the DOR system. And that's what we're mandated to do, to protect the person's legal rights as they go through the DOR system, to make sure a person understands their rights, understand you know, services that they may be eligible for through the program and what the Department of Rehabilitation can do as they go through. And we are there to advocate on their behalf to make sure that they get the services that they need. For example, if a person is applying for services and they get a denial letter saying they've been denied, well, we know what the laws, rules, and regulations are under the federal government as far as eligibility and all of that that we're going to talk about in a second for Department of Rehab services. So we want to make sure that the department followed the law in making their determination of the person was not eligible. So let's just look at that, and I'll talk a little bit more about how we would advocate in that case. When we look at slide 9, it talks about eligibility, the eligibility criteria. Now this was taken right out of the federal regulations as far as an individual being eligible for services, for rehab services. You must have a mental or physical impairment. This impairment must impede your ability to obtain or maintain employment, and you must be able to benefit from vocational rehabilitation services in terms of achieving an employment outcome. So let's say, as in my example, let's say if you apply to the Department of Rehabilitation and they take your application, they get your information and everything, and then they send you back a letter saying that you're denied services and you're not eligible for services. Okay. Well, you know, as it indicates on the slide down at the bottom, it indicates that if you receive SSI or SSDI, you're what they call presumed eligible. That means they presume that you have a mental physical impairment, presume that this is a substantial impediment to employment. So now they have to prove whether you can benefit from services. So the Department of Rehabilitation may write you that letter denying you, saying you can't benefit from services. So usually our clients get that letter and they're like, well, I thought I have a disability, I want to go back to work, this and this. And so what we'll do is say, the first thing we say is send us that denial notice. Because we want to look at the notice to see why they are saying they denied you. Because we know the rules and regulations, so we're going to see what they are saying. And then we're going to say, you have a right to appeal this, okay? And different states have different time limits for appealing a denial under Department of Rehabilitation. Here in California, is very generous. You have a whole year to appeal action taken by the Department of Rehabilitation. Now, within that year, there's some other things you can do, okay? Because if you ask for administrative review by the district administrator, once that review happens, then you have 30 days to appeal. Or you can, and even though there's a process they want you to go through first, we want you to try, and we will too. We will try to work it out with the counselor. If that doesn't work, we try to do with the supervisor. If that doesn't work, we try to do with the district administrator, and that doesn't work, then you have the right to file for a hearing. However, you have the right to file for a hearing at any time. You don't have to go through the process. Although with us, we want to do that because our job in protecting the client's right is also to be an advocate for what the consumers want. So we want to try to resolve the issue at the lowest level possible so you can get your services and move on toward employment. So that's how we work, and that's what RSA want us to do. Resolve it at the lowest level possible. But if we have to go further, and even if we have to go to a hearing and represent you at the hearing, we will do that if that's what we have to do. But most of the time, it doesn't get that far because we're going to make sure we hold them to the laws, rules, and regulations, and they have to prove to us. So in this situation of denying a person and you don't agree with it, and they may have things, and when you are eligible, when you apply for the benefits, they can do, DOR is going to do certain things to determine your eligibility. They're going to look at your medical records, they're going to look at your work history, they're going to look at all of this type of stuff or whatever. Then they're going to say, okay, maybe we need an assessment. Maybe we need a work assessment, or we need a medical assessment to see if you can work. And they send you off to assessment, and assessment might come back to say, hey, this person is not ready to go to work yet, or whatever. And you don't agree with it. And they deny you, saying, hey, you can't benefit from our services. Okay, that's one of the reasons they would say it, because you're not ready to go back to work yet. Or the assessment came out saying that you wasn't ready to work. So what we would do is, one of the things we're going to do, we're going to challenge the assessment. Because all assessment's not appropriate. It may not be the appropriate assessment for you. And also under the law, even if they do assessments, they must provide accommodation. You guys may not, and this is where assistive technology come in, because we have a lot of clients, DOR send them through an assessment, but they won't make the accommodation. They won't have the right type of assistive technology that the client may need to get there. But under the law, they must make accommodations in all phases of the rehab process. So we know what the laws are saying, and we're going to hold them to what the law says. They're going to, and the law says, and to prove that a person can't benefit from VR services, you have to prove that with what's in the law called clear and convincing evidence that the person can't benefit from services. You just can't say that they can't benefit. You have to show that they can't. So one of the things that we do is we make sure that the laws are followed as far as showing that clear and convincing evidence. And there are certain things that the department must do under the law to show clear and convincing evidence. Because if they just say, okay, we send them, for example, and I'm not picking on them, but I'm just saying, we sent them over to Pride, and the assessment came out, and the assessment wasn't right. And we don't think they can work. Oh, no. Well, maybe that was an inappropriate assessment for that person. Okay? So let's look at doing another, the law says let's look at doing an appropriate assessment with the accommodations that the person may need. Or there's a thing in the law called a trial work experience. That's where the department will do an assessment by sending you out to what they call an external situational assessment, where they would actually send you out to a job site. And it may not have to be what you're interested in, but what they're usually trying to test is your basic work abilities. Can you show up from work on time? Can you follow directions? All of these things that would happen, and how you get along well with other coworkers, all of that. That's what they're looking at in that assessment, in their work assessment. Now, this assessment may come out negative. Usually this assessment may run for a week, may run for 2 weeks or whatever. But whenever they're doing that assessment, the department will compensate you at minimum wage while you're doing that. But if this assessment comes out to be negative, okay, DOR might say, well, we sent Michael through this trial work experience, and he didn't do too well. He didn't show up on work at time, and he didn't call and tell him that he wasn't coming in. All that type of stuff. Okay. So we would say, under the law, it says a person can have multiple trial work assessments. So that's not clear and convincing evidence just to say they went through that one and they didn't do well. So we hold them to the law, what the law says. Now the DOR may not want to, and I understand, they may not want to go through all of that because they may not want to go through all the stages that the law requires. But that's what we're going to do as a CAP, as a client assistance program. We're going to make sure they go through all the steps that they do before they say that you can't benefit from the services. So that's our job, is to advocate for you and make sure that the laws, rules, and regulations are followed. Now, on slide 10, we look at some of the scope of services that the rehab can provide. Now, there are some core services like counseling and guidance and assessments and things of that sort that all departments of rehab must do. Okay, but there are also a lot of other services that they can provide. And like I said, a lot of them are listed in the CCR that I cite here, 7149. It presents a lot of those different services. But one of the services that we're talking about today, they rehab technology, rehabilitation technology. And that's what we want to look at. And at slide 11, I write out, this is from the, I remembered on the slide, instead of, I put rehabilitation technology and I put RE in parentheses. It may have been changed, but it's supposed to be an RT, so, But this is how it's defined. This slide shows the definition of rehab technology in the California Code of Regulation, and this coincides with the federal definition of what rehab technology is, and that includes assistive technology. And in slide 12, we give an account of, we also give a definition of what assistive technology is. Okay, and I'm also one of them people, and if it's I don't like to read to people, so that's why I'm just saying what the slide is, and it's there. And if you want that information, we can provide that, or you can always contact me, and I can go through all this stuff with you on a one-on-one basis, because believe me, there's a lot more to a lot of this than what we have here, but we just want to give you a brief overview. But DOR looks at assistive technology and assistive technology devices, and that's any equipment and technology or that a person may need to live independently as possible. Okay, and also with us, we also look at assistive technology services. That's on slide 13. Assistive technology services, or any services to help you get those equipment or anything you need, like training, or because I've had the thing where the Department of Rehabilitation has bought individuals who are blind and visually impaired and bought them the computer and bought them the software, and that's it. They haven't provided training on it or anything like that. So it's basically it makes it kind of not usable if you don't know how to use it. So assistive technology services also require that those services that's going to make sure that the assistive technology devices work be provided. And the reason I kind of highlighted them like that, because one thing I learned from working at a legal organization is that you have to, when you're advocating for an individual on a legal level, I learned this, and I learned it early, and I learned it painfully, is that you have to use the right laws and the right sections or the right regulations in your argument, or is very precise. So you have to use the right, when you're talking about like training and stuff like that. Well, that's not assistive technology under the law. That's assistive technology services. So some of us who don't come from this legal world, we're not going to look at it that way. We look at it all as part of one thing, But the law kind of separates it out. So once you just a little bit of how this stuff with DOR goes. When you're going to the Department of Rehabilitation, okay, as we always tell clients, the Department of Rehabilitation is there to help you go back to work, okay? They support employment plans. They don't support educational plans. So a lot of times we tell clients, when you go to the Department of Rehabilitation, you want to have a vocational goal. That's what job do you want? Some clients will say, I want to go to college. And believe me, I've seen the DOR orientation video, and they say it can help you. We can help pay for you to go to college. But actually, if you go in and say, I want you guys to help me go to college, they're going to say, no, we don't support educational goals. We support employment goals. Now, if you say, I want to be an accountant, and a part of your training to be an accountant is you have to get educational training, yes, they can pay for education. But it has to be a part of your training toward the vocational goal. And that may sound, may sound kind of simple, that little connection there, but you guys won't, you can't imagine how many cases we get with just that wordage, that language being, I want to go to college. And see, once you say that to DOR, then it's hard to kind of like back out of that, because all they see is this person is trying to get us to pay for them to go to college. So we try to tell clients it's about work. Now, all those service, educational, transportation, all those services that's provided in 7149, they're all a part of your services to get you to go to work. Okay, so that's what that whole thing is about, is getting you to go to work. Okay, so let's say if you go through, you're found eligible for services. Let's say all the assessment's been done, everything, and you're now eligible for services. One of the first things the department is going to do, they're going to send you a letter telling you're eligible, and they're going to tell you what's your category. And that's because under rehab law, under the federal law, the Departments of Rehabilitation must serve people with disabilities at a different rate. People with the most severe disabilities, they must serve them first. Then people with a severe disability, and then people whose disability is not severe. So there's usually 3 categories. They call it order of selection. And the law does that because when the state, say if the state has economic problems, which California did here a few years ago, they can only, they can only use those resources for the most severe. Now, Department of Rehab money from the Department of Rehabilitation is a combination of money from the federal government. I think in California, I think the federal government puts 79 cents into every rehab dollar, and the state of California puts in 21%. Now, for the states, that doesn't have to be 21%. Say if the total amount that you get for rehab money is, $3 million. I mean, $300 million. That doesn't mean that the state of California puts in 21% of that. They can do it. Each state can do in-kind contributions from other agencies that do certain things for the department. That can count also toward their 21% so that they can pull down the federal money to provide rehab services. Okay? Now, one of the things we also get in rehab is that even though that rehab money is there, the law says, the federal law says, and this is why I tell people sometimes, it's not just DOR trying to stop you or the counselors trying to stop you from getting services. Because the federal law says, it's called, the provision is called comparable benefits and services. What that means is, in federal law, before the state designated unit or the state rehab program can spend $1 of federal money on services to help rehabilitate a person, they must first seek out all comparable benefits or services that may be available. So they have to look at other things. So if part of your program is you need educational training, and so you have to go to school, well, the first thing DOR is going to say is you got to apply for financial aid. So if you get the federal financial aid, that has to be used first. And what we have to tell clients sometimes with that is when you get financial aid, it's not just to pay your tuition. It's to pay tuition, buy books, supplies, and all that. All of that has to be gone first before DOR would spend money on. So comparable benefits and comparable services, or even like we've had clients who want DOR to get them another wheelchair or whatever, or buy them get some other device, some assistive technology. The first they're going to seek out all other funding sources that can do that. They can get that for you. They may go to Medicare. Say if Medicare has a Medicare. They might even look at some of the with ability too. Some of the programs you guys offer. Okay, they may look at some of that to see if the person can get the assistive technology there first. But if they can't, then the department will have to come in and purchase that for them. So what we have to do is make sure of what's going on there. And the department has to, first we have to look around and see what other mechanisms that might be out there to get the services. And this is something in the law that they say the client or the DOR client and the counselor should do. Seek out all other services. For example, I just had a client a couple of weeks ago. He wanted to get he's an individual who's blind, and he wanted the department to buy him some assistive technology, from computers and all that stuff. But he's also a veteran, So the counselor, instead of purchasing that, she first looked at what the VA would provide for them, because the VA, and a lot of people don't know this, but the VA, the Veterans Administration, also has a rehabilitation program. So first she was going to find out why the VA would not provide this for her before the department. So that's one of the things we have to look at too, is those comparable benefits. Now, on slide 14, I think it is. Yeah, on slide 14, I talk about employment supports and work incentives, and basically that's the program I run, you know, the protection and advocacy for beneficiaries of Social Security. And the reason I wanted to throw that in, because I was just talking about comparable benefits and comparable services. Now, things under the Social Security program, these employment supports, work incentives, they are not considered comparable benefits. So the department can't say, oh, well, you need to use them first, because one of the most apropos, one of these work incentives that we use to help, especially to help individuals get assistive technology, is a PASS plan. That's a plan to achieve self-support, where if you're eligible, if you're SSI eligible, you have income other than SSI, you can set money aside into a separate bank account to purchase a lot of the things you need to meet your vocational goal. Okay? Now, and the reason I bring that up is because that's where myself and a lot of people, especially a lot of individuals who are blind and vision impaired, because years ago, I'm not going to date myself, but years ago, the Department of Rehabilitation, you know, buying assistive technology for a person who's blind was very, very expensive. So a lot of times, the department wouldn't do that, and there was nothing, you know, we basically was in the law that would say that. But in 1998, I guess I dated myself a little bit, but in 1998, the Rehab Act was amended to include what's called informed choice, and say that basically what the law says, that I, as a person who going to the Department of Rehabilitation, I'm a partner in this whole thing. You can't say what employment goal you want me to have. I can say that. I have to help you develop all my program and everything, and I participate as a full partner in this thing, and I have informed choice. That means I have choices that I can make. And also what was added to the law is that eligibility, to determine if I'm eligible for services, cost should not be a consideration. So you can't consider that. However, once I'm deemed eligible, now you can use cost to see if you can get something for a lower price but you can't use cost in the eligibility process. So that was a big change. But you still can't use like the PASS plan as a comparable benefit. So a lot of us, what we did back in those days, is we wrote PASS plans to get the equipment and the things we needed to help us move forward. Okay? So that's another avenue on how you can get the assistive technology. And matter of fact, I'm working with a client right now, because you can use these work incidents in conjunction with services from the Department of Rehabilitation to get the services that you need. For example, a few years ago I had a client who needed an accessible van. Now the Department of Rehabilitation, you know, it's very hard for them to buy the van, and also provide, I mean, some of the regulations about buying vehicles and everything for the Department of Rehabilitation is very tedious. It's very, a lot of people don't want to go through that. And the department don't want, they, you know, a lot of times they really don't want to buy the van and then do the accessibility. That's going to be a whole bunch of money. So they're going to look at comparable benefits. Now, a PASS plan is not a comparable benefits, but see, this client, they needed the van. And so when we talked to the department agreed that we set up a PASS plan, and we took it to the department. We said, hey, we're going to use a PASS plan to purchase the van. So the department agreed, once you purchase the van, since you got a pass plan to purchase the van, we'll do all accessibility. So the client ended up getting the van, and the department made sure that it was accessible, made sure she got the training on how to drive the van and everything. So what I'm saying is these things can be used in combination with services that you might be eligible for from the Department of Rehabilitation to get the assistive technology that you need. And also, if you know, there's, like I say, I run the Protection and Advocacy program, the PASS program, and there's a lot of things we can do if a person receives SSI or SSDI and they want to go back to work. There's different things that we can do to help that person go back to work, maybe keep some of their benefits in their medical coverage while they transition into work, and also, you know, use the work incentive to get those, get things that they need, some of that assistive technology. Sometimes you may not want to deal, you know, you may not want to go through the Department of Rehabilitation, or Department of Rehabilitation, because of their process, and as a state agency, they got all these procurement procedures. It may be taking too long. I got a client right now out at Sac State. Well, she don't want to wait till DOR go through everything it has to go through to get her the assistive technology she needs. So we wrote up a PASS plan, and the Social Security Administration and PASS cadre approved the PASS plan. She's setting aside the money, and she's being able to purchase the stuff she needs right now. Okay? And another thing I always tell people about assistive technology and about DOR services in general, when the Department of Rehabilitation buys equipment or anything for you, while you're participating in the DOR program, that equipment and everything belongs to the department. You sign an agreement, a loan agreement that lets you use it while you progress into the program. At the end of the thing, say you go through and you get employed and everything, now the department has a choice. They can either get that equipment back from you. This is legal. They can have you return that equipment to them. They can sell you that equipment at a lower price, or they can just give it to you. But it's their equipment. It's not yours. Now, if you use the PASS plan or something with the Social Security work incentives, and you purchase something, whatever, it's yours because the federal government, because the Social Security program is a federal program, and the federal government don't want it back. Okay, so that's just another avenue as far as you needing assistive technology, and it may be quicker to get it through some of the other avenues, and then it may be where you can keep it on a long-term basis. But we use all of that stuff together, and our job as CAP advocates and PASS advocates, but CAP advocates with the Client Assistance Program, is to investigate all areas that's going to work for the consumer, because we are advocates for the client. We're not advocates for the Department of Rehabilitation. We're not confrontational. We're not their adversaries. We don't just come in there and want to sue them and this and this and this, all that. We don't do all of that. We want to make sure that the laws, rules, and regulations of the Rehab Act are followed, so that the clients can get the services they need as quickly as possible so that they can return to work. And so that's all we do. And what we do is we say all the time to the DOR counselors and supervisors and DAs, is if you're following the regulations, you have no problems with us. I mean, why would we have problems with you if you're doing what you're supposed to do? But we're around because a lot of people don't. And we know, and a lot of people, a lot of clients and consumers don't know their rights. They don't know their rights. Because a lot of this stuff, if you don't do this stuff every day, you don't know this stuff. So when you go to these different agencies like the Department of Rehabilitation and everything, you don't know. When they say you can't, you know, we deny you service, if you don't know that there's stuff in the law that protects you, most of the time you're not. We have people come back to us 2 years after they've been denied. and say, hey, I didn't agree with this, but I didn't know I had a right. But see, we can't do anything on that case at that time because your year is up. So that's what our job is, to protect the rights of people with disabilities. And as a person with a disability, I'm very sensitive to that because I had personal experiences going through these systems, and I, you know, had some hard sledding there sometimes, but I learned what my rights were and what I could do and what I couldn't do and how to progress through the system. And I used services from the Department of Rehabilitation and from the past plan and everything. And I went through Cal State Sacramento, got a master's degree, paid for all the assistive technology and all that stuff I needed so that I could advance in the workplace that we all want to do. So on slide 15, I just threw up some other little websites that you could go to that has information on you know, your rights to rehab services and also assistive technology concerns. So these are some websites that might be useful and you can go to and look at to learn more about your rights with rehabilitation services, and also like DB 101 is, we put that together years ago to help advocate for people with disabilities and tell them what their rights are and return to work issues. We have the Department of Rehabilitation on there. If you want to go and you know, if you have insomnia and you want to read the regulations, you can go and do that. And you know, so and also you can also come to our website, Disability Rights California, because we have a lot of fact sheets that we've developed as a client assistance program. We have a lot of fact sheets on a lot of different aspects of the rehab program, instead of that can explain different aspects of that program to you and what your rights are as you go through that program. So that's pretty much what I wanted to share with you guys this morning, and like I said, you guys can contact me at any time. Slide 16 have my contact information. You can contact me anytime as far as issues with the Department of Rehabilitation or with Social Security Administration when there's issues about going to work. And I also do a lot of advocacy around employment discrimination and reasonable accommodations and all of that stuff on the Title I and Title II, Title I, II, III of the ADA and everything. So I just wanted to give you guys a brief rundown of some of the assistive technology and how you go about doing that, and some other options. Because once you determine eligible with the Department of Rehabilitation, and I didn't include the slide here, but I should have. Once you determine eligible and you have your vocational goal and you've done the assessments and everything is moving forward, then you get with your counselor, and that's when you develop an IPE, which is an individual plan for employment. And in that IPE, it states your vocational goal, it states the steps that you're going to take to reach your goals, and it also states what the Department of Rehabilitation, the steps they're going to take, the services they're going to provide, and all of that. And what we always want advise clients to make sure that you have those things in the IPE. Matter of fact, with the client assistance program, we can provide assistance to a person even when they get ready, when they're about to apply for DOR services, because we want to let you know what your rights are and what's going to happen all the way through the rehab process. Even with the IPE, we have clients go through DOR, they develop the IPE, and before they sign it, they will ask us as the client assistance program to review it to make sure that it's done correctly and it's viable and it's going to be to their benefit. Now, the IPE is not a contract between the client and DOR. It's only an agreement. It's not a legal contract. But if something happens and we have to go to a hearing or something like that, that's a real good piece of evidence there, because it's agreement they agreed to do. And if they're not providing those services, now they're bagging out an agreement, and the judge or RSA is going to want to know why. So it's a strong piece of evidence. So within that IPE, we want you to list the assistive technology that you want. Why, you don't have to do that in DOR, because you're going to talk to the counselor. Is why you need the assistive technology and the training and all that. So we make sure that you put all that stuff in, not only the equipment, but the training on it, and maybe upgrades and things like that. Because all that stuff happens, to get you a piece of equipment or get you some assistive technology that maybe in a year or so is not going to be useful to you. DOR don't want that, because then most likely you're going to come back to them and try to start the process all over again. They'd rather just do an update and then they'll go back and buy new equipment. So these are just some of the ins and outs of what happens with assistive technology in the Department of Rehab that I wanted to bring to you guys this morning. But as I said, there's a lot more to it. Because of a lot of the DOR regulations, both from the federal and the state, that we deal with on a daily basis. And as far as that's concerned, I am the client assistant program advocate here in the Sierra Nevada district, which is District 1 of Department of Rehabilitation. So if there are issues or concerns or questions that you would have about the Department of Rehabilitation, I would probably be the one that you can contact, and you have my contact information there. So since we didn't have any questions as we were going through, I would answer any questions that you may have at this point.
Okay, Michael, it looks like Eddie Lopez from Independent Living Resource of Contra Costa County has a question.
Mm-hmm.
Hi, Michael. Good morning. How are you doing today?
Oh, pretty good, pretty good.
Yeah, I have a question in reference of the rights, of a client that goes to DOR. And let's say that a person, is denial. I mean, the DOR inform the clients of their rights and appealing process and where to go, to look for assistance. Like the example that you mentioned about this person that went 2 years later, and looked, it went to your office and all that. If DOR mentioned that to him, like when the service was denied, he probably would go through the process and try to get, whatever he was trying to get.
What's going to happen most of the time is, once the person, and I forgot to mention, I'm just going to mention this because you're in Contra Costa County, and I want everybody to know that Disability Rights California is a statewide organization. We have offices in Oakland, LA, San Diego, Fresno. So we cover the whole state, and we have CAP advocates in every office throughout the state. Okay, so I just wanted to make that clear. But to get back to what you're saying, what usually happens is when they send you a denial notice, in the notice they'll say, included are your rights and remedies. They give you a sheet of paper and it tells you what your rights and remedies are. Now they're not going to tell you that, but see, under the law, long as you notify, and that's why they say, oh, we notified them. So, and a lot of times, and I understand what you're saying, because a lot of times people want to tell me what's going on. They realize that, and they can go and they can say, oh, well, we included the rights and remedies. So the client, on them, they're saying the client should have read this, and this client should have done this, and should have, which, believe it or not, that's what the judge is going to say. So they include that in with they're supposed to. And most all denial notices I've seen when they send them to clients, they enclose the rights and remedies. But then again, most clients, and in that rights and remedies, it should tell them that they can contact the client assistance program. But a lot of times they don't sit there and they don't talk to the clients. And let's just face it. I mean, let's just be perfectly honest. I'm just going to say me, for example. I got a denial notice. I'm not reading anything further. I'm pissed. So if somebody don't tell me, and then when you ask them about it, they're going to say, well, did you read the rights and remedies? So legally, they doing that. Legally, that's that, as we call it, that's the CY, that's that cover thing. But they are supposed to include the rights and remedies when the person first applies for benefits and they're there with the counselor. The counselor is supposed to inform them of their rights and remedy and inform them of the client assistance program. All of these things is what they're supposed to do. Now, notice I'm saying supposed to. Sometimes it gets done, sometimes it doesn't. I mean, it's the same thing, you know, like with Social Security. They give you a sheet of paper. And you may not read it, or you may have read it a long time ago and you forgot about it, but then the law says you were notified. So what we have to do as advocates is try to do as many, like I say, many presentations and outreach and get to a lot of advocates and say, hey, we deal with your rights on a daily basis. You don't have to go out and reinvent the wheel and try to learn what your rights are. Contact us. Most of the time, what I train my CAP advocates to do and what we try to get the clients to do, because DOR would tell you, there are the orientation video and the counselors would tell you, and even their handbook would say that they give clients, their client handbook would say, when you have problems with the Department of Rehabilitation, you can go to the client assistance program. Well, you don't know that you got problems until it's too late. So what we try to do is we try to go around to orientations, talk to clients, let clients know about us and everything, so we can explain those rights to you. We will send you, regulations. We will be there to talk you through everything that you need, but we have to pick up the ball there. That's one of our biggest areas of getting this information out, because even though the agency is supposed to notify you, sometimes they don't. They just include the rights and remedies, and a lot of times we may not look at those rights and remedies, and then our time run out. But one of the things, too, let me just say this real quick for the next question. One of the things, too, you always can reapply for DOR services regardless of how long it's been. If you're still eligible for services, you can still reapply.
Okay, I understand that part. Yeah, that is very good and insightful. But I never deal, with any consumer, going to DOR this time, so far. So I don't know much of the process about it. But I know, from other state or county agencies, they try to provide that information up front when something has been denied, any service has been denied to them, and tell them, they have this many days, to submit, an appeal, et cetera, et cetera. So many of the, like in your case, when you first came in, to DOR, how was it? Was it through your school? You did it through an agency, or you did it on your own? And that's what I'm wondering, when people do apply for DOR services, when they do it through their own, they're probably more, subject to not to know, many of the process and and how to go about filling out forms and requesting services or equipment, et cetera, et cetera. And so that's what I think, when consumers at that point, they are more, because they don't have an advocate, to explain them, what is it that they need to do. So how those people, can they and it goes to the same thing, that DOR denying something and not providing, all the information. It just give you, like a halfway information, and it's up to the person, So that's my concern,
Yeah, and that's my, I've been concerned about that, and that's why I try to look at the laws and see how we can work around them, because and this is in another context, but I remember I went to a hearing on a Social Security issue, and one of the first things the judge said to me is that we live in a country where information is free. Those are his benefits. He's the one who wants services, so he's responsible for knowing that. All they have to do, they gave him the paper that explained it to him, and it's on him to to have to keep up with it and do this, and which, you know, legally, yeah, right, okay, cool, you got it right, whatever, but actually practical, that doesn't happen. Okay, it doesn't happen that way. Like you say, people need, you have to explain things to people sometimes, and not just because people don't understand, but just to tell them, you know, what's going on. And that's what but we are working with DOR to be more explanatory to clients when things happen, instead of just send them on the way. But see, most of them will tell you, oh, I got a caseload of 150 people. I don't have time to sit there and explain this and explain that and whatever. And that's what we're up against. It's a thing about, and I understand what you're saying, it's a thing about, as we say, changing the culture. I always say to people, laws can change behavior, but they don't change attitudes. So we got to change the systemic attitude of a lot of people, not only in DOR, but a lot of agencies who don't do that, to be more customer service. And one of the things we try to push, and I push with the director, is that if it wasn't for the individuals with disabilities, the DOR wouldn't have any consumers. They wouldn't have any jobs. So it's to your benefit to make sure that you provide good customer service. And, you know, it's just a thing that we have to keep pushing and keep trying to get out there. But it is, and that's one of the difficult things that we face, but we try to keep working on that every day.
Yeah, that is correct what you just said. You know, if there wasn't because of disability, people with disability, DOR wouldn't even exist. I mean, the other thing is that we have to take in consideration that, you know, we're dealing with people with disability, and some of them, you know, they may have a disability how to process information.
Yeah,
you know?
And that's why
we physical disability that we can see.
And that's one of the things that even in that situation when it's a person that where the time limit may have elapsed, then we look at the person's disability. Look, as advocates, we bring everything that we can think of into the mix, the challenge. It may be because of the disability, you know, and a lot of times and not saying that we haven't, because we have gotten cases that haven't been appealed after that year in, and we have gotten them reopened. But in one of the cases, it was just as you were saying. It was because of the person's disability. Just giving them a piece of paper is not going to make it. As a matter of fact, I had a friend of mine who's visually impaired, who's totally blind. That's what they did to her. Well, how's she going to read that? She don't know what's on that paper. Nobody told her anything. They didn't put it in Braille. They didn't do all. So that's what we do. We hold them accountable, and it's not always the consumer's fault. Okay, on a lot of these things. We need to, and that's why sometimes when we get to investigating these things, we would go back and we would look at the files. We would go back and review the files and see what happened and see what was going on and everything. Because we want to make sure that every legal stone that we can overturn, we want to do that, because we want to make sure clients get the services that they're eligible to receive.
Hi, Michael. Thank you for answering that. So there's one last question. Are you familiar with the California Agribility Project? That's not part of the question. I was just wondering.
Not totally. I mean, we've had a client who was working with that project.
Okay, just for everyone attending, just so for purposes of the question, so the person asking the question is from the Cal Agribility Project. So for everyone who's not familiar, basically it exists to support farmers with disabilities who are trying to find different resources to help keep them farming. So their question was, you mentioned that DOR's goal is to have an individual employed. Why is it often more complicated to work with DOR when the individual is already employed or self-employed and accommodations are needed to keep the person employed? Is there a way to make this process smoother? I'm thinking in terms of keeping a disabled farmer or worker employed in a farm.
A good question, and that's one of the areas that I kind of push more than anything, because the rehab law just says to help an individual obtain, maintain, or advance in employment. So if the person, even if the person is working, if they need services so that they can maintain their employment, then those are, and if they meet the eligibility requirements, there's some services that the Department of Rehabilitation should look at providing. Now, the thing is, the eligibility requirement is that if the person, let's say if the person is going to lose their farm or not be able to continue farming because they need some type of services because of their disability, that's something that the department should look at. But just to help you maintain your employment or to get some type of more advanced equipment because that could make it easier on the disability, they're not going to pursue that, because in their sense, you can maintain that without for example, I may not be explaining to some. To give you an example, I had a client. She had a hearing impairment. Okay, she wanted them to provide her these hearing aids that was directional and that would cut out noise and whatever. But the federal law says they don't have to do that. They just have to give her the equipment that can help her to hear. Okay? So what I'm saying is they don't have to, like with me, they don't have to provide me, which would make me more efficient in my job, which would make everything, they don't have to provide me the touchscreen CCTV that's going to make me more efficient. They just have to provide me a CCTV that magnifies the print so I can see it. So if I need the equipment, and without the equipment, I'm going to lose my, I'm not going to be able to farm, and most likely I might have to end back up on Social Security disability or something like that. If because of the disability, if I don't get services, I'm going to end up losing my farm and basically maybe back on disability. Those are services that they must look at, because the whole object of all of this is to get you to a point where you're working and you move off of SSI or SSDI. They don't want you on the public benefits, so that's why they're providing services. So if it's going to be a threat to you losing your income to the point where you can qualify for those benefits, that's something that they should look at, providing services. But it's going to have to go through the eligibility process and say, okay, can I continue to be a farmer even if, I may want this certain equipment, but without it, can I still be a farmer? Or still, and basically what the department does, and when I first started doing this bugged me to death, because I looked through all the regulations, tried to find out what does the government considers substantial employment. What level do DOR has to get us to? And under the law, there's really no standards. It says if a person is working at a job that, now they can't place you in something that makes minimum wage. They can't they can't do that. Less than minimum wage. You have to make the minimum wage or more, and you have to be able to entitled to all benefits that other people are entitled to, or self-employment, you're making at least minimum wage from what you're doing. Because if it's below that, then you're not at substantial employment. But the law says if a person is doing that and they're working at minimum wage, they don't even care how many hours a month you're working. But if you're satisfied with it, after 90 days of this, they can close your case successfully. So there's no criteria that it got to be a full-time job or you got to be making so much money. As long as it's minimum wage, that's what they're concerned with. Because once you, so the law is once you start making that minimum wage and you're on that job for 90 consecutive days, the department can close your case as a successful, as they call it, a 26 under the law. They can successfully close your case. Now, if there's something because of your disability, you're gonna lose. Most likely, you're in jeopardy of losing your employment because you don't have these certain services. But it has to be because of your disability. Then they can come in and provide those services, post-employment services. But they really, you know, that's really very short-term service. So it can be done, but it has to be that you're going to be in jeopardy of losing your employment or not being able to farm or something like that.
Okay, thank you, Michael, for answering that question and for the presentation in the whole. I'm sure everyone is going to leave here knowing something they didn't know before. So for those of you who are still around, please stick around to, and CalAgrability responded to you, Michael. Thank you. That was really helpful.
Okay.
So those of you who are still around, I would ask you to please stick around. I'm about to bring up the webinar, a link that you can go to respond and give us feedback on the presentation and give Michael feedback. So I really appreciate all of you for attending and Michael, you for presenting. Thank you.
Thank you.